Welcome back to CT Education, your home for learning in all forms, shapes, and sizes. Today we are diving deeper into the fascinating world of trademarks, specifically in the South African context. In our last video, we pondered the question, what comes to your mind when you see a distinctive logo, a unique name, or even a specific product shape? Well, in often cases, it's a trademark. Now, a trademark is essentially a badge of origin, as mentioned in our last video. It's how businesses distinguish their goods or services from those of their competitors. Think of it as a unique identifier in the marketplace.
In today's video, we'll be looking deeper into the Trademarks Act. So what makes a trademark registrable under the Trademarks Act? Firstly, a registrable trademark must be distinctive. This is crucial. Section 9 of the Trademarks Act defines what makes a trademark, or a mark per se, capable of distinguishing the goods or services of one person from another. Essentially, it must be unique enough to identify a specific source. However, not everything can be registered even if you try. Section 10 of that Act lists various reasons why a trademark might be rejected. For example, a mark is not registerable if it looks too much like an existing registered trademark, making it likely to confuse customers. Also, if you're not actually using the trademark or don't genuinely plan to use it, such a mark will not be registered. Now, let's look at specific sections under Section 10. Firstly, Section 10, subsection 1 outlines that if what you're trying to register doesn't actually fit the definition of a trademark, it can be registered. For example, if it's just a general sound, smell, or sensation that isn't unique or can't be clearly shown, it might not count as a trademark. It needs to be something tangible and distinguishable. For instance, it may be a unique name or logo, and you must intend to use it in your business. Section 10, subsection 2 outlines that your trademark needs to be distinctive, meaning it can't just describe your product or be a common word in your industry. For example, your trademark can't be the word sweet for candy or fast for delivery services. These words simply describe what the product or service is. Another example is that a bakery can't trademark freshly baked for bread because it's a common, descriptive phrase for that type of product. The mark must be able to truly set your product apart. In the case of Pepco Retail versus Truworths, the court confirmed that generic terms are generally off limits for trademark registration in their respective industries because they don't distinguish one business from another. Let's move on to Section 10, subsection 5. Now here, you cannot trademark a shape, color, or other feature if it's purely practical or necessary for the product to work, or if it's needed to achieve a specific technical outcome. This stops companies from monopolizing essential designs. For example, you couldn't trademark the common shape of a car tire, as the shape is essential for its function. Similarly, in the Belcham Group case, the generic shape of an antibiotic tablet couldn't be trademarked because it is functional. Example 2. You generally cannot trademark a common color for a product if that color is just functional or ornamental, or it would stop other businesses from reasonably using the color. Think of yellow for butter or white for milk. These are standard colors, not unique brand identifiers. Now let's move on to Section 10, subsection 11. This section clearly outlines that if registering your trademark, like a specific product, shape, or container, would unfairly prevent a whole industry from developing or using certain designs, it will not be allowed. For example, if a company tried to trademark the basic cylindrical shape of all beverage cans, it would hinder the entire drinks industry. The law aims to prevent monopolies on general designs that everyone in the industry might need to use. Section 10, subsection 13, on the other hand, outlines that a trademark can be rejected if its use is inherently misleading or likely to confuse customers about the product or its origin. The law wants to protect the public from being tricked. For example, if you tried to trademark a half-bitten apple, it would be deceptive and generally not accepted because you're projecting a false origin and confusing customers. These rules ensure that trademarks genuinely help consumers identify products and prevent unfair competition, keeping the marketplace clear and trustworthy. Now, there are many more subsections under Section 10, which you can go find under the Trademarks Act.
Now let's delve deeper into distinctiveness. Purely distinctive words or words commonly used in a specific industry often cannot be capable of distinguishing. Consider the case of Pepco Retail versus Truworths again. It highlighted yet again that generic terms are usually off limits for trademark registration in their respective industries. Think about it. Can you register apple as a trademark for fruit? Probably not. But apple for computer? Absolutely. The context is key. Similarly, freshly baked for bread would be difficult to register. What about a shape, you may ask? Well, for a shape to be considered capable of distinguishing, there are very specific criteria that have to be met. It must depart significantly from the norm of that sector, act as a source indicator, and factually possess a distinctive character. This is why the unique shape of a Kit Kat is distinct, but the generic shape of an antibiotic tablet, as seen in the Bertram Group case, might not be registerable because it's functional or necessary to obtain a specific technical result. Colors too can be problematic if they are merely functional or ornamental and will deprive competitors of reasonable right of use. Now, the Act also specifies marks that are simply prohibited from registration. This includes marks that use or contain the national flag, armorial bearings, state emblems, or official signs and hallmarks of South Africa or another convention country, unless there is due prior authorization. Section 10, subsection 10 also prohibits marks specifically forbidden by regulation under the Trademarks Act or the Merchandise Marks Act. An example of this include the World Cup 2010 marks, or even words like Rooibos or Honeybush for tea. This is due to their specific regulations. Now, beyond regular trademarks, we have special categories like certification trademarks. According to Section 42 of the Act, a certification mark is a word, phrase, symbol, or design owned by one party who certifies the goods and services of others when they meet certain standards. The owner controls its use, but the mark itself is used by others to indicate that specific characteristics like kind, quality, value, or geographical origin have been met. Great examples in South Africa include the Proudly South African mark, the SABS mark, and the Pure Wool mark. These marks tell you, the consumer, that a product adheres to specific verified standards. Now, beyond regular trademarks, we also have collective trademarks. When it comes to collective trademarks, a group of traders can register a collective trademark for use only by its members. The purpose is to show that a member of that association or organization provides goods or services associated with it. Here you can think of the Stellenbosch Wine Roots logo. It tells you that the wine comes from a specific collective of wineries in that region. Other examples include Pepper Dew and Currant Beef. Now, collective trademarks are covered under Section 43 of the Act. It is important to note that the Act also sets rules for the applicant themselves and vigorously protects third-party rights. According to the Act, the applicant must be the true proprietor or adopter of the mark and file it in good faith. They must also have a bona fide intention to use the mark, Bad faith or malicious intention can lead to refusal of registration. Now these are covered under Section 10 subsection 3, 10 subsection 4, and 10 subsection 7. Now, third-party rights are protected under the following sections. Firstly, we have Section 10 subsection 3. This section protects well-known international trademarks. If a new mark is a reproduction, imitation, or translation of a well-known international mark and is used for familiar goods or services, causing likely deception or confusion, it will be refused. The next section is Section 10, subsection 12. This one protects against marks that are inherently deceptive or likely to deceive or confuse, or are contrary to the law, or contra bonus, meaning against morals, or are likely to give offense. The primary purpose here is public protection, with the likelihood of confusion being the overwhelming factor for success in opposition. The courts consider various factors, often summed up by the Plascon-Evans-Paynes case, which emphasized that comparing the marks based on sense, sound, appearance, and assessing their impact on an average cautious customer with imperfect recollection in the marketplace. Section 10, subsection 14, and 10, subsection 15 protect against marks confusingly similar to already registered trademarks or earlier applications, respectively. If the new mark is identical or so similar that its use for the relevant good or services would likely deceive or cause confusion, it will be blocked. Section 10, subsection 17 offers protection against dilution of well-known registered trademarks. Here, if a new mark is identical or similar to a well-known registered South African mark, and its use would give an unfair advantage to the applicant or cause unfair detriment to its owner or existing owner, or affect the distinctive character or repute of the registered mark, registration will be refused. Importantly, for Section 10, subsection 17, it is not required to prove the likelihood of deception or confusion. The Black Label case is a famous example illustrating how the registration of a mark can cause harm to the owner of a well-known mark, even if direct confusion isn't the primary issue.
A unique challenge for new inventions is avoiding a trademark becoming generic. Sometimes a brand name becomes so synonymous with a product type that it risks losing its trademark protection. Think of names like Creepy Crawly, iPod, or Jacuzzi. The Creepy Crawly, invented by Ferdinand Chauvreur from Springs in 1974, became a worldwide trade name for swimming pool vacuum cleaners, a testament to its success, but also a challenge in maintaining its distinctiveness as a specific brand rather than a generic term.
So, what if two businesses have been using very similar brands for years, and the one discovers the other has prior registration? This is where honest concurrent use comes in, under Section 14 of the Trademarks Act. Ordinarily, if two marks are confusingly similar, the one with the earlier application date is accepted, and the later one is refused. However, Section 14 allows a trademark to be registered even if it offends against sections like Section 10, subsection 6, 10, subsection 14, 10, subsection 15, or 10, subsection 17, which would normally preclude registration. Now, how does one succeed with an honest concurrent use application? Well, the application must prove that the adoption of the trademark was honest and concurrent. This requires submitting evidence, typically in the form of an affidavit, demonstrating at least 5 years of honest and concurrent use prior to the date of application. The affidavit would need to address points as set out in the Alex Perry and Sons Limited 1993 case. which include the degree of likely confusion, the fact that the choice of the applicant's trademark was honestly made, the extent of the honest concurrent use, whether or not there has been actual confusion, and the nature of the respective traits. The Trademarks Office will consider the evidence submitted and, if satisfied, accept the trademark as a Section 14 application. While an honest and concurrent use application can be more costly due to the evidence preparation and additional formalities, it's an effective way to register trademarks that would otherwise be rejected. It's very crucial to conduct a thorough search before filing to identify any potential issues and to determine whether such an application is necessary. Now, here's something interesting to note. Trademarks are not static. They can be bought, sold, and licensed. The ownership of a trademark can be transferred. This act is known as the assignment of the trademark. This can happen through a sale agreement, liquidation of the trademark owner, inheritance, or even legislation from other countries. When a trademark has been transferred to a new owner, there is a legal duty on the new owner to take appropriate steps to register the change of ownership with the trademark registrar. Furthermore, a trademark owner or licensor can grant permission to another party, the licensee, to use their trademark on mutually agreed terms and conditions. Historically, a trademark indicated the source, but with licensing, the product might come from a different entity. This is why quality control is paramount in trademark licensing. The licensor must maintain control of the nature and quality of goods and services sold in association with their trademark, ensuring that the brand's reputation is upheld. This is why you see brands like Checkers and Pick n Pay selling olive oil with clearly different branding, but potentially from a licensed producer, yet still maintaining their own quality standards. And that wraps up our deep dive into the world of trademarks in South Africa. We moved from registrability and objections to honest concurrent use and licensing. Understanding these concepts is vital for businesses and consumers alike. If you found this video helpful, give us a thumbs up. Subscribe to City Education for more insightful content. And let us know in the comments what other legal topics you'd like us to cover.